Good afternoon, friends. Let us dive into another case law, which is newly added into the Advocate on Record examination. The title of the case is Association for Democratic Reforms versus Union of India. This case was decided on 15 February 2024. The bench comprised of Honorable Chief Justice D.Y. Chandrachud, Honorable Justice Sanjeev Khanna, Honorable Justice B.R. Gawai, Honorable Justice J.B. Pardiwala, Honorable Justice Manoj Mishra. Friends, the question in this case was whether the non-disclosure of funding to political parties under the electoral bond scheme violates voters' right to information. Second question was whether unlimited corporation funding to political parties interferes with the free and fair elections and equality. I am repeating the questions. First one is whether the non-disclosure of funding to political parties under the electoral bond scheme violates voters' right to information. Second question was whether unlimited corporate funding to political parties interferes with the free and fair elections and equality. Now, let us dive into background of the case. French Finance Act 2017 amended the provisions of the RP Act 1951 and IT Act 1961 and Companies Act 2013. Section 29C of the RP Act was amended to allow political parties to not disclose campaign contributions received through electoral bonds. Section 182, subclause 3 of the Companies Act was amended to allow companies to now disclose details of the political contributions made by them. Section 182(1) of the Company Act, which provided a cap on political funding by companies, was removed to allow unlimited corporate funding. The provision also previously restricted the companies' contribution to their profit, but the amendment allowed even loss-making companies to donate. Section 13A of the IT Act was amended to allow political parties to not maintain a record of contributions received by electoral bonds. So, in January 2018, the government introduced the Electoral Bond Scheme 2018. Under this scheme, SBI was authorized to sell electoral bonds in denominations of 1,000, 10,000, 1 lakh, 10 lakh, and even 1 crore. The bonds allowed the identity of the purchaser to remain anonymous to everyone except the SBI, who recorded the buyer's know-how customer, that is KYC details. The buyer of bond would then give the bond to the political party they wish to denote to. The bonds would then be encashed by the political party. The petitioners challenged the constitutional validity of the electoral bond scheme and amendments made by the Finance Act, arguing that they prevented voters from knowing who was donating to political parties and it legitimized electoral corruption between donors and parties. The Union of India argued that electoral bonds were introduced for the purpose of curbing black money in electoral financing. The donors to the political party often apprehended retribution from other political parties that they did not denote. Such apprehension incentivized donors to contribute unaccounted money to political parties outside of formal banking channels. The union argued that electoral bond scheme maintains the confidentiality of the donor and thereby incentivizes them to contribute clear money to political parties through recognized banking channels. Now, let us explore decision of the Honorable Supreme Court. The Honorable Supreme Court held that the electoral bond scheme 2018 and the amendments made by the Finance Act to Section 29C of the RP Act, Section 182(3) of the Company Act, and Section 13A, subclause B of the IT Act are unconstitutional. The court also held that deletion of the provision to Section 182, subclause 1 of the Company Act permitting unlimited corporate contribution to the political parties, even for loss-making companies, is arbitrary and violative of Article 14. The judgment of the court was authored by Honorable Chief Justice D.Y. Chandrachud, Honorable Justice Sanjeev Kumar Khanna wrote a concurring but separate opinion. The Supreme Court also directed that SBI shall submit to the ECI by 6th March 2024, firstly, details of the electoral bonds purchased from 12 April 2019 till date to the Election Commission of India. The details shall include the date of purchase of each bond, the name of the purchaser, and denomination of the bond purchased. Details of political parties who have encashed electoral bonds since 12 April 2019 to date to the ECI, including details of each electoral bond encashed by political parties, the date of encashment, and denomination of the electoral bonds. The court directed the ECI to publish the information shared by the SBI on its official website within 1 week from the receipt of the information, that is, by March 13, 2024. Now, friends, let us dive into reasons for the decision. Close association of politics and money. Honorable Supreme Court noted that finance is crucial for electoral politics. Expenditure on political campaigns affects voting behavior because of the impact of television advertisements, campaign events, and personal canvassing. The court noted money also creates an entry barrier to politics by limiting the nature of candidates who can contest elections. Voters' right to information. Honorable Supreme Court held that the action of voting is a form of expression protected by Article 19, Subclause 1A, that is freedom of speech and expression. The court noted that the voters have a right to information that would allow them to cast their votes rationally and intelligently. And this includes the right to information about candidates. The court held that this right to information extends to political parties as well, as they are relevant political units in the democratic electoral process. And voters associate candidates with the ideology of their respective parties. The Supreme Court observed that an economically affluent person has a higher ability to make financial contributions to political parties. And there is a legitimate possibility that financial contributions to political party could be exchanged for political favor, such as introducing a policy change. The information about political funding would enable a voter to assess if there is a correlation between policy making and financial contributions. Now, then there is a test of proportionality. Honorable Supreme Court relied on the proportionality test to determine if the restriction on the fundamental right to information of voters is justified. The court held that a measure restricting a fundamental right must have a legitimate goal. It must be a suitable means of reaching that goal. It must be least restrictive measure and must not have a disproportionate impact on the rights holder. Privacy of donors. The Honorable Supreme Court noted that a stated goal of the electoral bond scheme was to protect the donor's privacy. The court held that the citizens have informational privacy over their political beliefs. Information about a person's political beliefs deduced through their political donations can be used by both public and private actors to suppress dissident, discriminate, or harass individuals based on their political views. The Honorable Supreme Court observed that Section 29C of RP Act mandates disclosure of information of contributions beyond 20,000 in one financial year. The rationale of Section 29C subclause 1 is that smaller donations up to 20,000 made by individuals do not have the ability to influence political decisions, and that the right to privacy of donors overweights the public right to information. But in the case of larger donations, they may influence policy. The right to information of the public outweighs the right to privacy of the donor. Applying the proportionality test, the Supreme Court found that the electoral bond scheme did not balance fundamental rights to information of voters with information privacy of donors. This scheme completely tilted the balance in favor of the purpose of informational privacy and underserved the informational interest of voters. The Supreme Court also held that political parties in power may have additional access to information regarding donation and that the privacy of donors can be breached. That the entire objective of this scheme is contradictory and inconsistent. Justice Khanna, in his separate opinion, held that the claim of privacy by a company would be restricted to the extent of protecting the privacy of individuals responsible for conducting the business of the company. Since the affairs of the company have to be open to the shareholder and the public who interact with the body corporate, it is very difficult to claim a violation of privacy by such body corporate. Curbing black money. Honorable Supreme Court applied the proportionality test and noted that there are other alternatives to curb black money, which are less restrictive to the voter's right to information, such as electoral trusts provided under Section 2, subclause 22AA of the IT Act. In an electoral trust, details of both the political parties and contributor are maintained and provided to the income tax authorities. Which contributor had donated, what and how much amount to which political party is not disclosed, thus balancing the privacy of donors and right to information of voters. Further, the RP Act mandates disclosure by political parties only of contributions of more than 20,000 in a financial year. So far, contributions less than 20,000, there is already anonymity under the law. The Supreme Court concluded that on an overall assessment for contributions below 20,000 contributions through other means of electronic transfer is a lesser restrictive means. For contributions above 20,000, contributions through electoral trust is less restrictive means. Hence, electoral bond scheme is not the least restrictive means to achieve the purpose of curbing black money in electoral process. Constitutionality of unlimited corporate funding. The Supreme Court noted that proviso to Section 182, subclause 1 of the Company Act, before it was amended by the Finance Act 2017, limited the contribution by companies for political purpose to 7.5% of its average net profit in the preceding 3 years. The Finance Act removed the proviso and allowed unlimited contribution by companies to political parties, and also by removing the net profit requirements, allowed even loss-making shell companies to donate to political parties. The Supreme Court noted that the main reason for corporate funding of political parties is to influence the political process, which may in turn improve the company's business performance. Unlimited contribution by companies to political parties is engaged free and fair election because it allows companies to use their resources to influence political making, policy making. The Supreme Court held that amendment to Section 182 is manifestly arbitrary as it places a profit-making company and loss-making company at an equal footing, and also a corporate and an individual on an equal footing, without realizing that the degree of harm arising from donation is higher in case of companies, especially loss-making companies. Justice Sanjeev Khanna, in his separate opinion, held that invalidity of amendment to Section 182 of the Company Act, which allowed unlimited donation, was more properly analyzed using the proportionality standard than the manifest arbitrariness standard, as the proportionality test ensures reasonableness. So this is all about this case. God bless you all. See you again. Share and subscribe my channel, my humble